Okay, well, welcome everybody to PMCA's Employment Law Fundamentals series. I'm Lori Rawlings. I'm the Executive Director of PMCA. I'll be kind of the moderator today, dealing with housekeeping things. I want to go over a couple of housekeeping things before we get started today. We are recording the seminar today. So for those of you who don't wish to be have your faces in the recording, feel free to turn off your video. I want to give you a disclaimer before we get started as well. We are providing general information about the law here today, and although our presenter Lauren Russell is an attorney, she's not providing legal advice in this presentation. If you do need legal advice about a specific situation, please contact your attorney. I'm going to ask that people remain muted when they're not speaking, but if you do have a question, feel free to raise your hand or unmute yourself to jump in with a question. You can also use the chat feature. If you would like to ask a question, you can either send the chat to everyone, or if you would like to ask it anonymously, feel free to do a chat directly to me, and I'll be monitoring the chat for any questions. And that's basically it. So at this point, I'm going to turn it over to our presenter today, Lauren Russell. She is an experienced trial attorney who, with the Dunn Carney firm here in Portland, Oregon. She specializes in employment litigation and advice and business disputes and personal injury cases. She's tried several jury trials to verdict and has a lot of experience with arbitration as well. So without further ado, I'm going to turn it over to Lauren and thank her for being here today. Welcome, Lauren.
Thank you, Lori. Appreciate it. And thanks everybody for signing up for this. I know it was non-mandatory, so you're getting extra credit for this. Please excuse any technical difficulties while we're just getting this rolling. For example, it looks like I'm sitting in a dark basement room. I have a very old camera on my computer, so I'm not sure what to do about that. But
you look great. The lighting is great.
Luckily, my face is not important for this training. So I'm going to start sharing my screen. Hopefully, can we see this?
I can see it.
Great.
I'm assuming everyone else can as well.
Okay. People can let me know if something isn't working. Now I just need to find here we go. Oh, lawyers doing tech, it's tricky. Okay, so like Lori said, this is the first part of a 4-part series about it's more of an introduction to basic topics in employment law. This is not meant to be a comprehensive, cover everything. We just don't have enough time, but we want to kind of do a general overview of 4 major areas within the law. Today's session is going to be wage and hour fundamentals. So I just want to preface this by saying I'm going to be covering some wage and hour basics. Some of these will apply to all employees, regardless of a union or non-union. Some are going to apply just to your non-union staff. And I'm not covering the master labor agreement today. So if you have any questions on that, I'm sure you're all pretty well versed in that document, but that's not going to be the topic of this presentation today. We're kind of sticking to the more Oregon law specific provisions that will apply most generally. So that being said, we'll get started. All right, I'm just going to minimize that. There we go. Okay, so as you probably know, and I'm primarily covering Oregon, but California and Washington are going to be thrown in as well, since I understand you do business in those states. So we're an at-will state, just like California and Washington. That means, generally you can terminate an employment relationship for any reason by the employer or the employee, unless the relationship has a specific duration or, a specific condition, such as jobs that need to be completed or something like that. A written contract isn't required for an employment relationship. It can be oral. It's not a formalistic, we don't take a formalistic approach here. So Exceptions to terminating, of course, would be you can't terminate an employee based on anything that would violate a law seeking to protect employees, such as anti-discrimination laws, that kind of thing. And then, as you know, you can also violate a collective bargaining agreement. But other than that, if an employee is a chronically late employee, we can terminate. That's a general kind of description of how that works. Oops, let's see here. Okay, so a wrongful discharge is where you discharge an employee and there's a motive behind it that is harmful or interferes with an important interest of the community. And we generally lump these kinds of wrongful discharges into two categories. First being you terminate an employee for fulfilling a societal duty or in violation of a social policy. So that means we can't terminate employees for being serving on a jury when they're called for service. You can't terminate for whistleblowing, reporting misconduct, and you can't terminate for an employee refusing to break the law, such as, if they're asked to disclose confidential financial information of a customer, maybe this would be at a bank or that sort of thing. And then the second category these broadly fall into would be an employee pursuing a right of public importance, which our state has determined includes filing workers' compensation claims, resisting supervisors' sexual harassment, that kind of thing. We can't terminate employees for going against the law and pursuing their own rights when they're being wronged in an employment scenario. And then a constructive discharge is when essentially you make the working conditions so untenable, that implicates a protected class status or protected activity. An example would be, allowing sexual harassment of an employee. So under those circumstances, an employee just quits because the working conditions are so untenable as to amount to a discharge, essentially. All right, we'll go right into minimum wage requirements. So this one's kind of basic too. For non-exempt workers, that means hourly folks who aren't paid a salary for the most part, they must be paid no less than the minimum wage for all hours worked. And sometimes where employers trip up is, what does hours worked include? That includes basically any time an employee is taking direction from the employer and is required to be in service of the job. That includes travel time, not typically to the job site, but if you're traveling within job sites, or if you have to travel out of state or out of the city for work, it's confined within the regular workday hours. Any trainings, such as today, if we were requiring employees to attend, that would be paid time. That would include hours worked. And then on-call time, if an employee is not free to use the time for their own purposes, if they must, for instance, if they can't go out of town, if they must, be within 10 feet of their desk, something like that. And then one thing to note here is that even if the employer did not authorize or direct the work, and if employee has performed work, it must be recorded and paid. That may seem kind of frustrating, but that is the law. Another big topic is paycheck deductions, another one where folks can sometimes get in trouble. We have a pretty strict requirement for when an employer may deduct or withhold employees' wages in Oregon. So exceptions to the general prohibition on deductions would be if you're required to by law. So that makes, Social Security, taxes, if there's been a writ of garnishment, you're allowed to withhold. If the employee signs a paper in writing saying that you may deduct and it's for their benefit, such as 401k contributions or for the health plan. Again, another written authorization that's for something not for the employee's benefit, and the employer also tracks it. An easy way to think of this would be like if you work in a restaurant, so if you're purchasing a meal on shift or some other kind of service, that must be tracked and there must be a written authorization to deduct. As you know, collective bargaining agreement, if that authorizes the deduction, you can deduct. Processing fees for complying with a writ of garnishment is one example. And then another one that's kind of tricky that we don't really recommend is when employers loan employees money. And so you can deduct at the end of an employee's tenure an amount to repay the loan if that loan agreement was in writing. And again, there's additional statutory requirements for that. It's just kind of a sticky situation. So we don't really like to see employers loaning employees money. So some requirements, you must give the employee an itemized statement of the deductions. That usually shows up on a pay stub. That's typically where we see those. And then if an employer is complying with a writ of garnishment or some other requirement to deduct, those amounts have to be paid within 7 days of the date the deduction is made, or if there's another time specified by the law or an agreement. And so this is important here. Failure to do that can constitute an unlawful deduction, even if you are lawfully authorized to deduct that amount pursuant to a writ of garnishment. And that can subject you to penalties, which can include the actual amount of the deduction plus up to 30 days of 8 hours a day wages, plus attorney fees if there's a lawsuit. So you really have to be careful in the deduction realm. And in Oregon, you can't deduct cost of tools, equipment, uniforms, clothing required by an employer. If an employee breaks something, you can't deduct that from their wages. And then for this, I would just say if you face this, if the deduction issue in California or Washington, definitely check those statutes, consult your lawyer. They're pretty dang similar, but you really want to follow the letter of the law on these. So do look at those in detail if that situation arises. Here is another, I'll just add to that. You can seek, if an employee, for instance, steals something, if they steal tools, or if they fail to return part of a uniform and that's worth something, employees can pursue recovery of that amount through the legal process. You can't do self-help. You can't go to an employee's house and take back the tools, or you can't deduct it from their wages, but you can, file a lawsuit in circuit court to seek those amounts. So it doesn't mean that's just lost to you, but the way to go about that is not to go through an employee's paycheck and deduct those amounts. And like I was saying, those penalties can really add up. It can be a maximum of 30 days wages, 8 hours a day times the rate of pay, plus the actual amount of the deduction, plus, attorney fees and whatever, anything else the court might award, interest on that amount. So you really want to be careful in that realm. Okay, I think I've hammered that home. So overtime is another one of those areas you need to be careful about, as I'm sure you all know. Non-exempt workers, you have to pay 1.5 times their regular rate of pay, worked in excess of 40 hours in a work week. This is for non-union folks. And then a work week is a 7 consecutive day period set by an employer, and then begins at the same time and ends on the same time every week. And this is just, I'm kind of reiterating here, failure to pay overtime also subjects you to those penalty wages, up to 30 days, liquidated damages. So that means for every day that you delay to pay, if the employee can prove they were harmed, they can recover that. And attorney fees and costs, which it wouldn't surprise you probably to know, can get very expensive. All right, on to meal periods. So in Oregon, you must provide a 30-minute or longer meal period to non-exempt employees who work 6 or more hours in one work period. And you need to try and stagger that so that it falls about in the middle of an employee's shift. So you'll see if it's 7 hours or less, the meal period must come between the 2nd and the 5th hours worked. 7 hours or more, take the meal period between 3rd and 6th hours worked. And if it's a 14 hours or longer work period, you must provide additional meals, and you would provide them about every 4 hours there. Okay. So you can't make an employee work during their meal period in Oregon with 3 exceptions. So those would be unforeseeable equipment failures, acts of nature, what we call other exceptional and unanticipated circumstances, whether if it's an industry practice or custom where you don't allow 30 minutes, but you have to allow at least 20 minutes. Not very familiar with situations in which that comes up, but I'm sure it does. And then if the business can show it would be an undue hardship to provide the 30-minute meal period, you can get that, you can be relieved of that without the, if the business can show it would be an undue hardship for the employee not to work during the meal period, then you can get an exemption for that, but you have to meet a showing of undue hardship. And the labor department is not really keen on that. So something to keep in mind. And then of course the CBA can modify these rules to apply to the situation at hand. Washington and California look pretty similar, but we'll just go through those quickly. Washington, again, 30 minutes when a non-exempt employee works more than 5 hours in a shift between the 2nd and 5th, similar to Oregon. And then there's kind of a squishy requirement where if they work longer, you may need to provide more depending on the length of the shift and timing. So you would probably recommend every, for additional 4 hours work, provide a meal period. It must be paid if employee is required to remain on duty and or on call. And if an employer calls an employee back to work at the 28th minute of the meal period, that must be paid. The whole thing must be paid. They must get 30 minutes total. You can't shorten it for any reason. And then if you do have your employee work during the meal time, those hours count as hours worked for overtime purposes and leave accrual. So pretty employee favorable in Washington on that. If you don't require your employee to work during the meal period, you can do it unpaid. They must be free of all their job duties during the entire break. You can require the employee to remain on site. Again, they don't have to work during that if so. If they're unpaid meal breaks, they are not hours worked for purposes of overtime and leave accrual. And an employee can waive the meal break, but it has to be an agreement between both employee and employer. Employer cannot go ahead and waive it for employee. And here we're at California. You'll see again, we have 30 minutes. 5 hours is the benchmark, needs to be a meal period, can't take it at the end of the 5 hours. If you require the employee to work, perform some of their duties during the meal period, it's on duty, so it means hours worked and you have to pay them. And you can only require an employee to have an on-duty meal period when the nature of the work requires them to be performing some of their job duties, and if there's a written agreement between the employer and the employee. So you have to have both of those things to require the employee to do their meal periods on duty. Along with this, we have rest periods, which I know you're also familiar with. So again, we'll go through Oregon, Washington, and California, which are pretty similar with some small distinctions. So Oregon, it's paid rest periods of at least 10 minutes every 4-hour work period in the middle of the work period. You can't add it to a meal period to expedite things. That's against the law. You can't add it to the end of a work day. It needs to be taken separately in intervals throughout. And another one that's changed in recent years that folks may not be aware of is now employers must provide quote unquote reasonable unpaid rest periods for employees who are breastfeeding and need to express milk, and that lasts until their child is 18 months old. And these are at the employee's request. You can't limit the number. You have to grant them when the employee comes to you and says, I need a break for this purpose. Additionally, you have to make another quote unquote reasonable effort to provide a place where these employees can take these breaks. So that means a private place to express milk. It can't just be your public bathroom or a stall. It's supposed to be close to an employee's workstation, and concealed from view, and which wouldn't allow people to intrude on the employee. Again, this is kind of a squishy, if one reasonable isn't defined, close to an employee's workstation isn't defined, it's kind of a use your best judgment situation. But it's important to know that you can't, aside from the limitation of the age of the child, you can't limit the employees if they're requesting to take this break for this purpose. All right, Washington, similar, at least 10 minutes every 4 hours. Try to get it close to the midpoint of the shift. Employee cannot be working on this rest period. 3 hours max without a rest period. That's it. You can require your workers to stay on site. You don't have to allow them to go to the corner gas station or anything like that. And in Washington, these rest periods count as hours worked. And again, with the quote unquote reasonable unpaid rest period for the expression of breast milk, the age of the child is different here. It's 12 months of age. And a similar requirement as in Oregon, you need to find a place for an employee to take this break that isn't just a bathroom, where they're not in view and free from intrusion. Some workplaces now are setting up specific rooms for this that have locking doors. My workplace does. It's called a meditation room / nap room / use for this purpose, has locking doors and that kind of thing. So something to consider. I know not every workplace can accommodate that. And then in California, still talking about rest periods, again, 10 minutes every 4 hours, right about the middle of the work period. And here is something interesting to note. If the employer doesn't allow a rest period, you have to pay the employee 1 hour of pay, a regular rate of pay for each workday they don't get a rest period. So that's more than the end result of that is that a rest period is, quote unquote, worth more in California than other states. So you really want to be, employers really should be complying with this in California. Otherwise, they face a penalty of 1 hour pay for each rest period they don't allow. And similarly, again, the breast milk expression break time. California is a little more specific of what the location for the employee needs to include. It must be, they actually say it must be safe, clean, contain a surface to place the breast pump on and a place to sit, access to power, an outlet, a sink with running water, and a fridge. And these breaks are to, ideally run concurrently with other break time, and then they'll be paid breaks. If they don't run concurrently, then they are unpaid. Something to keep in mind. All right, we are on to final paychecks. I'm moving fairly fast through here, so we might have some time at the end, or we might let you out early. Final paychecks is another area that's really important to comply with, as you probably know, because it also is subject to penalty wages if you fail to pay on time. So in Oregon, in the situation of an employee quitting without notice, all wages are due 5 business days after the termination or the next regularly scheduled payday, whichever occurs first. If an employee quits with 48 hours or more notice, not including weekends or holidays, then all the wages are due on the last day worked. And then if there is some sort of mutual parting of the ways, then the employer is expected to pay wages by the end of the next business day. Here's where the penalty comes into play. If an employer willfully, that's another term of art legally, withholds wages after the employment ends, you must pay the employee a penalty of 8 hours per day at their regular rate of pay for up to 30 days. Willfully is, you don't want to risk litigation over this term. An employee's attorney will certainly argue that the withholding of the wages was willful. And if the employer had notice of the employee's termination and didn't pay, it could be a dicey argument to try to say that it wasn't withheld willfully. And again, employees can get their attorney fees paid under these statutes for failure to pay termination wages. So really important to comply with these requirements. Washington is simpler. If employee quits or is fired, the final paycheck is due on or before the next regularly scheduled payday. You don't have to worry about timing there, although it might be kind of a hustle to get the check together. California, a little different. For any reason, employees terminated, that final paycheck is due immediately at time of termination. So that includes all their accrued vacation, bonuses, commission, all expense reimbursements. I'm not exactly sure how that would work if an employee hasn't submitted those, but it's very employee favorable. Again, California, not surprising. If the employee just quits and they don't give any notice, you have 72 hours to provide the final paycheck, but it must include all of those items that we discussed above. And then if they quit with at least 72 hours notice, it's due at the time of termination. Again, including all the money the employee is owed to date. Right. This is one that I doubt would distinguish between union and non-union staff. Or employees, excuse me. So in Oregon, and same as Washington and California, employees have the right to inspect their own personnel records, which essentially means their personnel file, with some notable exceptions. Personnel records are not defined to include confidential reports from previous employers. You do not have to allow an employee to see those. Records obtained regarding an arrest or conviction involving criminal conduct. And then there's some other exceptions that are specifically statute-based or, Department of Higher Ed, college disciplinary records, that kind of thing. But everything else, application, discipline on the job, everything else that you would include in an employee's personnel file, they get to inspect. You can charge for the cost of copying. You can't charge any sort of premium, but you can charge for the cost you incur to make a copy. And within 45 days of the request to inspect, the employer must provide the employee a reasonable opportunity to view the records at their workplace. This is a pretty strict deadline in my world. We typically get requests from employees, plaintiffs, lawyers to have a copy of the personnel file within 45 days. And this is an important deadline to comply with. And the law says you must maintain these records at least 60 days post-termination. I'd recommend longer, I'd recommend a set period of at least a couple of years. And then violating the law, again, subjects the employer to civil penalties. So again, another reason to keep close watch on these deadlines if employers see a request to inspect records. So Washington actually spells out how long to keep the records, which I like, minimum of 3 years. I think that just makes sense. Employee can request a copy at any reasonable time. And then upon that request, employers have to make them available within a reasonable period of time. It's usually about 10 days, a little faster than in Oregon. And then this just allows the employee to, take photos, make copies, that sort of thing at the workplace. In California, again, we see this reasonable language. This is a, word that lawyers don't love and courts like, but so not less than 30 calendar days from the receipt of the written request. That seems, that seems realistic. If they request a copy, you must provide that within the 30 days, and you can charge for your copying costs, but not anything above that. And California also has a minimum 3-year retention period, which we like. Okay, I breezed through that, everybody. Hopefully I didn't talk too fast, but we can do questions, or else we also have a quiz, which is not graded, but it's, to see if you were awake during the presentation. So
it's to reinforce learning. So why don't we pause at this point and invite anybody who has a question. feel free to just jump in if you have a question. If you feel more comfortable putting it in the chat, I'm keeping an eye on the chat. So feel free if you have anything that, any questions about any of the topics that Lauren covered this morning.
And it's, a lot of this stuff is probably pretty familiar, so my feelings won't be hurt if you don't have questions, but the next few sessions will be a little lengthier and meatier, so can look forward to that.
There is a quiz coming up, so if there's anything you didn't understand or want repeated, now would be a good time to jump in with a question. The quiz is not graded, but I like to try to do the best I can on a quiz, even if it's not graded. So now's your opportunity to clarify or have things repeated.
You and I are type A, Lori, we're the same.
That's why I won't be taking the quiz. Also, I'm not sure I have the ability to actually take the quiz as the host, so. Okay, here's a great question. What takes precedence in Oregon regarding wage and hour? Are we talking the collective bargaining agreement or state law? It's a great question, Lauren.
Yes, so where the collective bargaining agreement does not address something, it will be Oregon state law. For your union folks, your first step will be to look at the collective bargaining agreement and then state law, because the collective bargaining agreement, from my understanding in a brief scan, complies with state law or is more generous. So you can, that document for your union folks is controlling. And then where it doesn't speak to another issue, such as the breaks for, expressing breast milk or, final paycheck, no, that covers that. But anytime that it doesn't cover one of those topics, you look to state law. And then of course, for your non-union staff, they're not covered. So then state law is the automatic option there. Hopefully that makes sense.
Yeah, that's really helpful. And, just to kind of elaborate on that, you are, as employers, still subject to state law with regard to your union employees, even though there's a collective bargaining agreement in place. So that's something important to keep in mind. You do need to have a working familiarity with all of these different employment laws, because your collective bargaining unit members are in most cases entitled to the same protections under these laws as all of your other employees. So it's really important to be familiar with your obligations under the laws, and to have good employment counsel available to help you with specific questions. Okay, that was a great question. Any other questions?
Thank you.
Okay, if you guys want me to launch the quiz, I'm going to launch it, unless anybody else has a question they want to jump in with.
I say go, let's do the quiz.
Okay, here it comes. Okay, can everybody see the quiz? So if you want to, if each of you could take a moment to go through the quiz and just respond with your answers, I think this will be a good reinforcement tool for all of you. Again, it's not graded. Your answers won't be shared with anyone. I think it's just kind of a good opportunity to think through what we've talked about this morning. And if it generates any questions for Lauren, feel free to jump in or type a question into the chat. So I'm going to give everybody about a few minutes, and I'll stop talking while you read and respond.
You can probably see me doing it on the screen, so I won't do it.
Yeah, you want to share your screen? That'd be great.
Yeah. I almost did. I almost just spilled that out.
People are responding. That's great. I'm going to give you a
Good.
few more minutes and then we'll walk through the answers. So Lauren can explain the answers to each question.
Well, they probably know I didn't make them too hard, I don't think.
Okay, I'm going to give people one more minute. It looks like most everyone has responded. So we'll go to 12:40 and then we'll go through the answers. Okay, I'm going to end the poll and then I'm going to ask Lauren to walk through each of the questions and answers.
Great. Thank you.
You're so welcome. Okay, can you guys see the poll results?
I can
Excellent.
speak for the group.
Okay, all right, Lauren, I'm going to ask you each question and why don't you walk me through the correct answer?
Sure.
So question 1, which of the following are considered hours worked in Oregon? Select all that apply. A, training. B, on-call time if employee not free to use time for own purposes. C, work performed during meal period. And D, breaks to express milk. What's the correct answer or answers, Lauren?
I want to do this in Jeopardy, but I feel like I'll mess it up. So correct answers here are A, B, C. Training, on-call time if the employee can't do whatever they want on that time, and work performed during the meal period. These are all hours worked and need to be paid wages. Breaks to express breast milk are unpaid in Oregon. So these do not count for hours worked.
Okay, and are there states where breaks to express milk is considered paid time?
In California, if you tack it on to a break period, you have to pay. But if it's taken, that's kind of a strange law. So if you're already taking your 10 and you tack on another 25, then it doesn't, it can be paid. But if you just take it randomly in the middle, of a shift, it's not paid, which is interesting, but that's California for you.
Okay, so that one we had about 67% of the respondents respond that breaks to express milk were considered hours worked in Oregon. So that's something to be aware of, that they're not actually considered hours worked in Oregon. Okay, next question. True or false? In Oregon, an employer can deduct the cost of uniforms required by the employer from an employee's paycheck. Is that true or false?
That is false.
Excellent. 100% of our respondents answered correctly. That's great.
And that my understanding that conforms with the MLA. Can't charge these folks for that kind of stuff. You can pursue legal action separately if needed, but can't just withhold it from a paycheck. So good job.
Good job, everyone. Okay, and then our final question. Number 3, in Oregon, if an employee quits without notice, when is the employee's final paycheck due? Select 1. So the choices were 5 business days or the next regularly scheduled payday, the last day worked, or the end of the next business day. What's the correct answer?
It is well, it's 5 business days or the next regularly scheduled payday. So well done, everyone.
Excellent. 100% correct on that answer. Great.
Yes.
Well, I'm really impressed. Obviously, everyone was listening very carefully. I'm very impressed.
Hey, Lori.
Yes, ma'am.
Lori, it's Corey. Question back to the breast milk issue. I learned that that is paid break time. So am I not understanding that correctly as of hours worked?
Great question. Lauren, can you clarify?
So the law is unpaid. As far as I know,
I'm looking at the Oregon bully, and it's considered a break. You get reasonable breaks as needed. And my attorney, so I said, can she, what if she just takes breaks for 8 hours? And that's acceptable. It's reasonable. His question is, it's got to be reasonable, but I have to allow as many breaks as necessary.
right.
So that can't
Yes.
be unpaid.
Well, my understanding is that you have to allow as many as necessary, but whether they're paid or I thought it was unpaid, and when I checked, it was unpaid. But because this is an important question, and it looks like, maybe a lot of people understood them to be paid, maybe I will take another look and then send an update if I am incorrect on that, because I do not want to be giving incorrect information. So yes to the as requested, reasonable, quote unquote, but let me follow up on the paid.
Yeah, because I was under the impression of, and I just got it like the most recent bully update for I think July 1st, new thing poster to print out, and it's the breaks and meal breaks, and you also get reasonable breaks as needed to express milk, and it doesn't say anything about them not being not paid. And so in dealing with my attorney, because I currently have an OFLA thing I'm dealing with, my attorney was very clear on she gets what she gets and it's all paid. So
let me confirm.
I'd like to know if it's a different law. I most definitely would like to know if that's
for sure.
If if there's another rule, please let me know.
For sure. Yeah, I don't want to try and navigate looking that up while I'm on the Zoom, because I just don't think that will be that successful for me. But let me double check, because it's an important issue, and then Lori can send out a clarification or confirmation to participants once I look that up.
Great question,
Thank
Corey.
you very much.
Thanks for bringing it up, and thank you, Lauren, for the additional legwork. And I will circulate the answer after the session today, so everybody is on the same page.
Yeah, and they did make that law much more employer friendly recently, so it is possible that I was looking at an older resource, but yes, we'll confirm, because that is important.
Excellent. Okay, anybody else have any other questions? It's a quiet group today.
Well, they're ready to go early.
Okay. Well, you guys have all been so good, and you all did so well on the quiz that I think we can let you out a little early today.
And next week is anti-discrimination laws, anti-harassment laws. So that'll be a pretty meaty topic. So come prepared and fed and hydrated and awake.
Yes, absolutely. And I cannot overemphasize the importance of really understanding those laws, because that is making mistakes in those areas and failing to take corrective action when necessary can result in very expensive claims and lawsuits. So this will be a great opportunity to learn and refresh your recollections and make any adjustments you might need to be making inside your internal policies and procedures. So I'm going to go around just to make sure nobody else has any questions before we adjourn today. Looks like we're good. So I want to thank everybody for taking the time to attend today over the lunch hour. I know you're all very busy, so I appreciate you joining. And I want to thank Lauren Russell again for an excellent presentation.
Thanks, Lori.
Okay,
thank you.
Thanks, everybody. Have a great week, and I hope to see you next week and for the following 3 weeks. Take care.
Thank you.
Bye-bye.